What happens in a real estate transaction when one side or the other doesn't perform? Good morning. My name is Mike Renick. I am the senior broker, the team lead of Team Renick Real Estate Services. We're part of that great Keller Williams on the Water family, serving Sarasota, Bradenton, the islands, in fact, most of the west coast of Florida. This is December 5th, and welcome to Title Time with Mike and Mike. My guest, as with every Wednesday morning, is Mr. Hankin, and he's waiting patiently in the lobby. I'm not bringing him in until I read the bio, because I like doing this part of the thing, and he never knows whether he's getting the long version or the short version, but in summary, he's just an all-around great guy. Michael is an attorney with the law firm of Hankin and Hankin. He practices primarily in the areas of residential and commercial real estate transactions. He is an approved agent for the Chicago Title Insurance Company, the Attorney's Title Insurance Fund, and the Old Republic Title Insurance Company. He has been designated as a board-certified real estate attorney, and that's a designation that's very difficult to achieve, and it's a designation that very few folks have. So with that said, let me bring Michael into the studio here. Good morning, Michael. How are you?
Good morning, Mike. Doing well, and yourself?
Not bad. Did I do okay? I kind of didn't do the short version, but didn't do the long version on the intro.
I appreciate any shortening of that you can do, so thank you. Just, hey, here's Mike is good enough for me.
But I love this. The fact that you're willing to donate your time to invest it into folks to help them through difficult real estate transactions, that really says something about who you are, your business model, and what you stand for.
Well, if you wanted to be cynical, I'm making people more comfortable so that their transactions are easier, which saves everybody time.
Yes, it does. And you do a great job with that. So today, we're going to discuss what happens when one side or the other kind of reneges from the deal, the contract.
Sure. So I wanted to discuss that and talk about first how you can be in default under your contract, and second, what happens if you are in default. So under the contract, and I'm referring to, as always, the normal as-is purchase and sale agreement, which is the most commonly used residential form in the state of Florida. And that contract provides that if the buyer or seller fails or refuses to perform any of their obligations under the contract, including the payment of any deposits, then they're in default. Pretty simple, pretty cut and dry. That has a lot of ramifications. What that means, in conjunction with another provision of the contract, the time is of the essence clause, that if you are 1 day late in making your deposit, technically you're in default as a buyer. If you fail to diligently obtain your loan approval from your lender, you're in default. Any of the other various obligations under the contract, obtaining surveys, obtaining your title search within the time period provided by the contract, all obligations, all things that can put you in default as a buyer. As a seller, you have one little wiggle room. If your title isn't marketable, but you've tried reasonably diligent efforts to make your title marketable, then you're not in default. But otherwise, if you fail or refuse to perform any obligation as a seller as well, that's default. So default's great, but what the heck does that mean? What happens from there when either the buyer or the seller hasn't done what they're supposed to? Well, the contract addresses this as well. It's in paragraph 16, which provides that the buyer and seller, after there's conflicting demands or a dispute between them, they have 10 days to try to work it out between themselves. Often the agents are involved in that process, helping with the negotiations, trying to work anything else out. But failing that, the contract would have it go to a mediation with an independent mediator, either somebody experienced in the real estate industry or somebody certified as a mediator by the Florida courts. Failing that, a lawsuit generally gets filed, and that can take months or years. So just something to be aware of there, that if you don't settle at that mediation, it can really drag out. Another interesting thing on dispute resolutions is the contract has an attorney's fees clause, which means that if the buyer or seller wins the lawsuit at the end of the day, the loser has to pay the winner's attorney's fees.
Wow.
So it's kind of an interesting thing. It really makes you double down on your position. So there's different views on attorney's fees clauses. Some people think that you shouldn't be punished for bringing your case to court, and if you lose, you should only have to pay your own attorney's fees, not the other side's attorney's fees. While other people say we should discourage litigation whenever possible. And so if somebody's going to litigate, they got to be absolutely sure of their position. And if they're going to pursue it in court, they're going to have to pay for it and pay the other side's attorney's fees if they're wronged. I don't know what the right answer is there. We haven't talked about this ahead of time. What do you think, Mike?
Well, I think the key, I have the easy out because my business model handles this like everything else, and surround myself with experts. So the key, and we offer this right up front to every potential seller we talk to or every potential buyer to bring an attorney into the transaction. When Eric and I are working with clients, attorneys, we understand the value that they bring and the help they bring. We're not put off or offended if a client wants to bring an attorney involved. So we as licensed real estate brokers can't practice law, nor would we want to. So we can explain some maybe high-level things, but they really need to understand that contract thoroughly. It's put out by the state of Florida, so we don't change it. But so my recommendation is that talk to someone that's familiar with Florida law and make the decisions that's right for them. What do you think about that?
Yeah, absolutely. No matter what the industry is, you want to talk with an expert. You want to talk with somebody who does whatever it is, the services that you're looking for as their primary source of income and business. They become experts in their fields, and especially with something as large and important as a home purchase, you want an expert on your side. There's some interesting little wrinkles that come into the default. So the contract and most listing agreements provide that if a buyer were to default, the deposit, the escrow deposit, not only the deposit that they put down, but also all deposits they agreed to put down, so future deposits, become what's known as liquidated damages. That means that the seller can take that amount without the necessity of having to prove that they were damaged in that amount. So if a buyer puts $100,000 down with a contract and defaults a week later, seller doesn't have to show that they lost $100,000. They just, in theory, become entitled to that $100,000. Now, the wrinkle is the contract and listing agreement provide by default that 50% of that deposit is split between the listing agent and the seller. And then the listing agent is supposed to take that deposit and whatever portion they get, split that equally with the cooperating agent. Okay. So it's interesting, the listing agent only has to split the portion they receive. They don't have to elect to receive anything. So when a buyer defaults, let's say there's a $100,000 deposit, it goes to the seller. You have an obligation to the seller as a single agent, but you also have been working with this buyer's agent for a while. Their buyer defaulted. Should you take that commission, that half the forfeited deposit, and split that with the buyer's agent? Or do you leave that with the seller?
That's a good question, because if I go back to the beginning of that, I think, and I've not been in this situation, but I think I would take zero commission. I think, the seller was the most disappointed. I worked for the seller. The house didn't sell. The buyer defaulted. I think the money belongs with the seller.
But what about this poor buyer's agent, Mike? I'm going to play devil's advocate here. This poor buyer's agent has done all their work. They sold the house. There's a commission that was paid through the forfeited deposit. The contract says that you're entitled to this 50% deposit. Why won't you just exercise the right that you're entitled to and get that half a deposit for the buyer's agent who's done the work and is entitled to it?
Well, so let's look at that. That's a great question, and I like that. There's a difference between ethics and legality in my mind. And ethics can be higher, but it can never be lower. Okay, breaking the law is not ethical, no matter how you spin that. So, in this case, I'm going to worry about the first fact, and the fact says the selling agent, myself, has the right to opt in or take 50%. It doesn't say that it's automatic. So first of all, at this point, I think that none of us, since the deal didn't close, has earned any of that. So that stays with the seller. Now let's look at the buyer side. We run that risk when we work with any client. Let's say we show a client around for 2 weeks and they opt not to write an offer. Well, that's how the real estate model is set up, and that's time invested that may pay off down the road, it may not. So there's always that risk because we're not paid time and material as we move along, like a doctor would be, if you would, or a dentist. When you go in, you have a bill that's due. So looking at it, I'm under contract with the seller. So my first thought is taking care of the seller. I see the other agent as a partner in the transaction. I get that, but and I can keep my held head high because I'm not taking 50 grand and saying to the other agent, you get zero. So I have to look at what's right for us first, and what's right for us would be zero, and then the chips fall where they may.
And I think that makes sense. You would still have the listing if the listing period hadn't expired, and although you have to work twice as hard and sell the property again, in theory, there's a payday at the end when it sells the second time. So, sometimes you work on a deal and it doesn't work out, and that's okay, and you work on and you move to the next one. So
that's our whole business model like that. We do the best we can. If a deal was meant to close, it closes. If a buyer was ready to write an offer, they do. We don't press, we don't push. We work extremely hard behind the scenes to make things happen for the client that we're representing, whether it's a buyer in a deal or whether it's a seller in a deal. But I really appreciate, I'm going to step back to what we said a couple of minutes ago, the ethical line of behavior can be higher than the legal line of behavior. And when that happens, I'm going to default to the ethical line of behavior. And it's really simple. People make ethics really hard. Ethics is very simple. And the way I define it, it's doing the right thing when you know nobody is watching.
That makes sense. And, I think there's a lot of good information here, and it's not always cut and dry. There are different decisions that are made that impact your clients, and those decisions, and certainly this example and in the real world, have real world dollar and cents implications and consequences. So having the right agent and the right attorney on your side, I think, not only provides the intangible benefits, maybe a better home or better title at the end of the day, but also tangible benefits in these situations where you wind up with actual more dollars in your pocket.
It's all about doing business right, surrounding yourself with experts, the right attorneys, the right mortgage folks, right inspectors, cleaning folks, lawn folks, all the above. And when you can deliver a product that includes all the above to your client, then at the end of the day, I think we've succeeded. And that's how we've built our business. We've been here only 8 years and came out of nowhere, and now we've been very lucky to be at least known in the area.
Really does take a village. That's pretty awesome. Well, we'll keep these up, and we'll have another episode next week, and continue raising awareness and increasing professionalism, and hopefully making these transactions a bit smoother, one episode at a time.
And I really appreciate your help, Michael. Thank you for investing the time, sharing your thoughts. And as always, have a great week. I will see you next Wednesday morning.
Thanks, Mike. Take care.
Take care.